Hi friends, this is Kaushik Ranchod, immigration lawyer representing clients throughout the 50 states. Welcome to my weekly immigration show. Today we're talking about the difference between applying for a green card in the United States and needing an I-601A waiver and a case study that goes along with that. You'll want to watch this video to really be informed. If you have questions, of course, you can call us at 916-613-3553, or you can just smash that like button and we can get started. All right, so let's talk about the I-601A and the adjustment of status, what the difference is, why one works, why one doesn't. I get this question a lot, so let's keep you informed so you know the difference and potential paths. Adjustment of status is the legal term for applying for a green card. So many types of cases that we do are based off of marriage or filing, if you're a US citizen, filing for a parent. The caveat here is that you have to have entered with lawful inspection with typically a visa demonstrating that lawful inspection. If you're applying for a green card, you have to enter on a visa. There are some limited exceptions to that, but generally you have to enter with a visa into the United States demonstrating lawful inspection. It's really important to know that even if you've overstayed, you're still eligible to apply for adjustment of status if you have an immediate relative, such as a US citizen spouse that's filing an application for you, or if you have a US citizen child that's filing for you who's over the age of 21, and if you entered with lawful inspection, this is also an option. But what happens if you've entered without a visa? That's the problem that we face, and that is where we need to use the tool of the I-601A waiver or the I-601. The I-601A is primarily if you entered without a visa, you've overstayed for more than 180 days or more than a year. So you have two situations there. If you've overstayed for more than 180 days, you'd be subject to a 3-year bar, and more than a year, a 10-year bar. So in that situation, if you've left the United States after entering without a visa, you'd be subject to a 3-year or 10-year bar unless you get the I-601A waiver. Now, the problem is you're not able to get a green card even if you're married to a citizen if you've entered without a visa unless you apply for a waiver. So the I-601A cures this unlawful presence option. There might be other ways as well to cure it, but the most common and straightforward way is the I-601A waiver. For instance, you might be eligible for asylum or something of that nature, but that's usually not the case. So we're going to be talking just primarily about the I-601A waiver in this video. This 3 or 10-year bar rule was created in 1996. It was supposed to incentivize people from not coming into the United States or leaving, actually having people leave the United States, but it really was, in my opinion, a not well thought out law. Of course, people are not going to leave the United States once they've entered, because if they do, they're not going to be able to come back in. So it really incentivized people to stay in the United States because you might be subject to that 3 or 10-year bar. So it was really not a well thought out law, but this is what we're dealing with today. So at least we have the I-601A waiver that could be a potential tool for you if you did enter without a visa. Now let's talk about, okay, well, you want to apply for the I-601A waiver. What does that process look like? First of all, you have to have a qualifying relative. Do you have a US citizen spouse? Do you have a lawful permanent resident spouse? Or do you have a US citizen parent, or do you have a lawful permanent resident parent? If so, then they can file the I-601A waiver on your behalf. The process has many steps in it. So the first step is filing the immediate relative petition demonstrating your relationship, and then after that gets approved, well, not just the immediate relative petition, because green card holders can also file as well. So filing the I-130 petition, that's one avenue, one common avenue in the I-601A process. After that is approved, then you can move on to the National Visa Center process and pay the filing fees. After that, you file the waiver. Then you actually go to the National Visa Center processing. I had a consultation a couple days ago where unfortunately the attorney told them to go directly to the National Visa Center process, but you can't actually do that unless you have the waiver approved. Previously, before the I-601A, there was the I-601. So in that process, you would, after the petition's approved, you would go directly to the National Visa Center process. Then you go to the immigrant visa interview. And then after your application would be denied because you technically were not admissible to the United States, you would file for the I-601 waiver outside of the United States. But Obama, when he was in office, the I-601A was created during his administration. And this has just been one big benefit for you who entered without a visa. Because before that I-601A waiver, you'd have to apply for outside the United States. Now you get to apply for the waiver inside of the United States. Okay, so you probably are waiting to hear for the case study. I know the law can be a little bit boring, but you know, I'm an immigration nerd, so I gotta share it with you. Let's dive into the case study and show how this plays out. We're gonna talk about how the hardships played out. So some common types of hardships are economic hardship, financial hardship, career hardship, medical hardship, mental health hardship. So those are some common types of hardship. Previously, extreme hardship was not defined until 2016. There were clear definitions that were laid out for extreme hardship, and they're really looking at family ties, social and cultural issues, economic issues, health conditions, and country conditions. These can be described in a variety of ways, like in the ways that I mentioned earlier, and there's different angles and different ways to tackle demonstrating extreme hardship. So let's talk about the case study where we were able to get a case approved. So in this situation, our client was originally from Mexico. He lived in the United States over 15 years. And the hardship to his U.S. citizen spouse, she had a medical hardship, financial hardship. So in this situation, our client didn't have a criminal record. If you have a criminal record and you want to apply for the I-601A waiver, you should consult an immigration lawyer because you may not be eligible for the I-601A waiver depending upon the criminal convictions that you have. Even a DUI, you should consult an immigration lawyer before working on your I-601A case. And a lawyer can just help you with this whole complex process that takes a few years or longer. Right now, as I am giving this video the entire process, hopefully that's going to speed up, but it is taking a long time since COVID has hit. So back to the case study. Okay, let's talk about the hardships of the U.S. citizen spouse. So we talked about, in this situation, the health hardship that the U.S. citizen had. So that included stomach issues, migraines, asthma, and we talked about all of those medical hardships that were there. And the U.S. citizen spouse was also of Mexican descent as well. The way that we were able to argue the medical hardship is that the condition would get worse if the U.S. citizen had to go to Mexico. And of course, you have to back this up with evidence to support that as well. Now, we also talked about how the U.S. citizen spouse relies on the applicant for providing the sole source of income to the family and even to drive. So it was really important to keep the whole family as a unit, and this would be extreme hardship if their income would be cut off. And imagine having public transportation while you're taking care of kids. So this was another factor that was brought up as well. So we were really happy to get this case approved. It's just another life that has changed, and that's why we do this. Our core purpose is unification, unifying families. If you have questions, I invite you to put them below, and make sure you subscribe so you can continue to get these updates, and we'll see you next week. Bye for now.